This pretrial review is in the matter of CFI 066-2023 and is being held by way of video conference before Justice Rene Lemiere, with a sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Charles Russell Speechlys. Lead counsel is Mr. Glenn Bull. The defendant is represented on a pro bono basis by Mr. Arvin Lee of Wee Swee Toe Advocates and Solicitors. Thank you, Your Honor.
Thank you. Very well. Well, Mr. Bull, we're listed for a one-day trial on the 20th of December. I've read your pre-trial checklist. I'm just going to bring it up whilst I'm talking to you. The only matters that come from there, I think, is first of all, you say you request that your witnesses be permitted to give evidence by video link. That is, this trial is listed for a remote hearing, so they will indeed give their evidence that way. Now, the other matter I see, I might go to Mr. Lee. Mr. Lee, on the list where it says which witnesses of fact do you intend to call, and you name the defendant, Alain Debar or Debare, Chloe Sharp and Ross McLaughlin. Now, Mr. McLaughlin is not on the claimants list, and so perhaps I'll go to Mr. Bull first. I assume from that you don't intend to call Mr. McLaughlin. Is that right?
Yes, Your Honour. Following the immediate judgment application, there is a very, very limited scope for this hearing. The evidence that Mr. McLaughlin provided was all dealt with in the immediate judgment application. He made one comment in relation to mitigation. The court has effectively said that that was insufficient, but we did then have an opportunity to provide new evidence. We have done that. We have two witnesses that have provided detailed evidence about the period from termination to the reletting of the premises. That shows a consistent effort of trying to find tenants over that long period of time. And that's the only evidence that I would think would need to be examined, if at all. I mean, as I will, perhaps it's a little bit too early, but I've raised at point 7 of my of the pretrial checklist that perhaps this matter really could be resolved on the papers, because there's no conflict in any of the evidence. The facts are agreed, and none of the parties' witnesses conflict with each other. It's purely a matter of interpretation of that evidence. And the stark contrast in that is set out clearly in the skeleton arguments. But I don't think a trial would actually help on that, because it's purely a matter of interpretation, that there's no conflicting evidence.
I'll ask Mr. Lee what he has to say about that. Mr. Lee?
May it please Your Honour, thank you. I do think that a trial is necessary because of the very unsatisfying way in which the evidence of mitigation has been coming out. First, Mr. McLaughlin said that efforts were made, but they did not bear fruit. But now Mr. Debar has been found, and Ms. Sharp have both deposed to the effect that efforts appear to be fruitful. That's the first point. And the nature and quality of the evidence also deserves to be challenged. And I think that at this point, the risk of giving away one cross-examination question, I don't know if Your Honour has got the trial bundle in front of Your Honour.
I don't. I've read the witness, the skeleton arguments, but perhaps it's not necessary to go to that, Mr. Lee.
Yes.
The view I hold is this, that if the defendant wants the matter to go to trial, then it should. And I must say, Mr. Bull, my experience tells me that that in the end is the most efficient and expeditious way to resolve the matter. Experience tells me that attempts to shortcut matters often go wrong and don't end up that way. So we will go to trial. As to Mr. McLaughlin, the position is this, that it's up to each party to decide what evidence they're going to adduce at the trial. If the if the claimant, Mr. Bull, wishes to adduce any evidence from Mr. McLaughlin or rely upon anything in the witness statements of Mr. McLaughlin, then it will be necessary to call him at the trial and he would then be available for cross-examination. If the claimant chooses not to call Mr. McLaughlin at the trial, then none of the evidence he's given in witness statements will be available to the claimant, but nor will he be available for cross-examination. It is open to the defendant to call Mr. McLaughlin if it wishes, but then, of course, the defendant would not be cross-examining Mr. McLaughlin. The defendant would be leading evidence in chief from Mr. McLaughlin, whether by way of his witness statement or otherwise. So that's the position. Mr. Lee, it may be that you would have or did want to cross-examine Mr. McLaughlin, but as say the claimant chooses not to call Mr. McLaughlin, that means the claimant will not be able to rely upon anything that has been said by Mr. McLaughlin, but Mr. McLaughlin will not be available to be questioned at the trial. All right.
I do have one query, Your Honour. We do reference one email that's in Mr. McLaughlin's bundle of documents. We don't reference any of his evidence in the skeleton arguments, and I don't think there's any particular need for that. But he did exhibit one email that we do reference, and for that reason, is it best that we call him?
Well, what is the email? It's an email from who to who, or what?
It's an email between one of the selling agents and or one of the employees of the claimant and the defendant. So the defendant is a recipient and writes back to that email too. So it's those two. It's a chain of emails between those two.
Well, I think the options are this. If the defendant agrees to the email going into evidence without it having to be produced by a witness, it may go in that way. If one of your other two witnesses is able to put it into evidence, that you could seek to do that. Failing either of those courses, you will have to call Mr. McLaughlin to prove the email. And of course, if Mr. McLaughlin gives evidence at all, however limited, is then available for cross-examination.
Right, Your Honour, what sort of leash will the questions, will the parties have in terms of questions? Because again, the scope of this matter is so limited. I just wonder as to, my learned friend has proposed a trial timetable whereby Mr. DeBar is deposed for an hour and a half. My anticipation was that a half-hour maximum would be really more than sufficient on such a limited scope.
Mr. Lee, are you able and willing to give any indication as to the scope of cross-examination of Mr. DeBar?
Your Honour, yes. Firstly, my approach is usually set out the maximum time that I anticipate. I may use less than that. I think it's far better to set out the maximum and to be short than to do it conversely. That's the first point. Now, Mr. DeBar, is giving two modules, if you like, of evidence, unlike Ms. Sharp. Ms. Sharp's evidence only goes towards attempts at mitigation. Mr. Debar's evidence goes towards attempts at mitigation as well as the date of termination. So I do think that there is the need for more time for Mr. Debar.
Well, as best I can answer, Mr. Bull, I would answer this way, that the evidence will be confined to matters which are in issue.
Mm-hmm.
It appears to me that the matters in issue are: when was the lease terminated, and what efforts did the claimant make to mitigate its loss by reletting the premises.
Mm-hmm.
Any questions which are relevant to those matters may be asked, and I take some comfort or hope in Mr. Lee's indication that his estimate is an outer limit rather than a lower limit of the time likely to be taken.
Okay.
All right, is there anything else that we should discuss today, Mr. Bull?
Not that I can think of, Your Honour. I think we are all lined up and ready to go effectively. It's been a long lead up to this point, and it would be good to get it finished in the new year. I suppose the one issue is perhaps the complexity around the costs issue, and whether or not we would there would be time on the day of the trial to have a submissions for cost, well, whether a decision would be made on the day and we would then be able to make submissions on costs, or whether a written statement at the end following the trial.
Well, I think there are at least two parts to the costs issue. One is what order should be made for costs,
Mm-hmm.
and the second is the quantum of costs. I think both parties, well, I'll go back a step. I do not intend to make a decision on the day. It's my practice to provide written reasons for my decision, and I prefer not to deliver a decision in advance of the reasons unless there is a good reason, and I can't see it in this case. I anticipate and expect that the parties can make submissions on costs in anticipation of the outcome. That is, in your case, Mr. Bull, I think there are a range of possible outcomes, but in broad terms, if you're successful, you get the amount you've asked for or some other sum, and you could make submissions based on that. So far as Mr. Lee is concerned, again, I think you'll have to anticipate what orders might be made and make submissions about that. Again, the submissions taking two forms. One, what order for costs should be made, that is, whether an order for costs should be made. If so, what form it should take, who should pay whom. Thirdly, whether I should make an immediate assessment of the costs or send them to be assessed. I think it'd probably be better for the parties if I'm able to make an immediate assessment of them, in which case you should make submissions about the quantum of the costs as well.
Your Honour, I'm just wondering if there is a way of anticipating the orders where then perhaps may have been offers made between the parties.
I see.
Yeah.
I see. Well, I think that probably means I should not make an order
Yeah.
for costs
Okay.
on the day.
All right.
I think in that event, I should just give a decision. And it might be, of course, we'll have to see how things unfold, but one possible and a course which I may well take is to invite written submissions in relation to costs and determine the costs on the papers so as to avoid any further hearing.
Yeah, I think that would be most suitable from our perspective.
All right.
Yeah.
Mr. Lee, or any matters you want to raise?
Your Honour, there's just a couple of housekeeping matters that I would appreciate Your Honour's directions on. Your Honour, note that the two issues that's before the court now, mitigation as well as termination date, they were issues that we brought up during the immediate judgment application hearing, and they were not pleaded as such in the papers. Does Your Honour require us to amend pleadings so that for completeness and close off this loop, or is Your Honour...
What are those issues, Mr. Lee?
Yes. So the allegation of a breach of duty of mitigation. The defendant's previous counsel has not pleaded that as such in the pleadings. That's the first thing. And on the date of termination, now there's two dates in question, 27th of October and 10th of November. 10th of November was mentioned by the claimant in a paragraph, and shortly after, within the same paragraph, there was a mention that the lease was terminated by parties' conduct. But the the claimant did not go as far as to say that it was as of that date. Yes. I see Mr. Bull nodding, so I think I've been fair to him characterizing his yes.
I might be wrong, Mr. Lee, and Mr. Bull, but in the claimant's skeleton argument, doesn't the claimant put forward a different date for termination?
Correct.
I think
We have,
it's
Your
some
Honour.
date in January, isn't it?
10 January, it's effectively, again, there's no certainty from either party. There are communications that continue until the 15th of December. Yeah. And then we have the natural period of parties putting tools down and enjoying Christmas and New Year and returning to the office, during which time another breach has occurred in terms of a payment that has been dishonoured. And at that point, right. It is the
I don't need to rehearse the arguments today, Mr. Bull, but I think the matters, as I see it, is this. I won't require the defendant to amend her pleadings. I think that will just add to the costs of the proceedings. I think providing that the defendant's arguments are essentially those in the skeleton argument, then the claimant has fair opportunity to meet those arguments, and the matter will be conducted on that basis, and it's not necessary to further amend. Mr. Lee, I do draw your attention to the fact you mentioned there were these two possible dates. I am confident you'd be aware that the claimant in its skeleton argument puts forward a different date, the 10th of January. So it would be all of those dates are dates which are in play, as it were, so that nobody is taken by surprise and everybody has an opportunity to properly address the case. Is that sufficient, Mr. Lee?
Your Honour, thank you for that reminder. I would say that, yes, given that Your Honor has indicated that there's no need to amend pleadings, I am happy with that. Just for completeness, Your Honor, may I check with Your Honor whether you think that it would be possible for you to give a written direction in that regard, just to, for the sake of...
All right.
Yes, thank you, Your Honor.
Yes, I will do that, just so that
Yes,
nobody is in any doubt
yes, obliged, Your Honor.
about it. All right.
Yes, that's the first point. The second point is that the trial bundle, there is Ms. Kakari's witness statement 5 and the exhibits not in there. I mean, it's I would imagine it is just a inadvertent slip, so I just asked Mr. Bull to include that in the trial bundle.
Of course.
Thank you.
Yes.
Yes.
I will add it to the bottom, just because this trial bundle system would renumber all of the pages again if I added it to the previous section. But if that's okay with you, Mr. Lee.
You can include it anywhere. It could be a fresh section, whatever, so that the logistical task is heavy for you. Thank you. Yes. Yes, yes. Your Honor, the final point, and just coming back to Mr. Lachlan. So I would imagine the best way forward would be for us to wait for the claimant to indicate what it expects, the approach that it expects to take with regard to the email that Mr. McLaughlin had abused in his witness statement. And then for us to state our response. Is that
right. Well, I will ask you to confer about that.
Yes.
Not now at this hearing, but subsequently, if you confer about that, and you can sort it out what you're going to do. If you're able to reach some agreement on it, all well and good. If you're not, then you'll just have to take the course which each of you sees fit.
I'm sure we'll be able to work that out quite promptly. And following that, we can then work out the schedule, being a mix, essentially what we've provided to you in this bundle, but noting your comments that no decision would be made and there'll be no need for submissions on costs that day. Yeah.
All right. Well, thank you.
I'm sorry, Your Honor.
Yes,
one final question, just to check whether you require, I suppose you do because you have not said anything, but oral opening and oral closing, and you do not intend to cut any of that. I don't
think we'll need any oral openings.
I see.
I have assumed that your skeleton arguments outline all of the arguments you have to make, albeit you may want to elaborate upon them. But is that right, that the skeleton argument identifies each and all of the arguments that you're going to make?
There was a couple other points that I was intending to make in oral opening, but Your Honor, I can save that over for the oral closing. And and they will, I will observe the usual put rules. So, not having an oral opening would not prejudice the claimant, so that we can dispense with the oral opening.
Yes, you happy with that, Mr. Bull?
Yeah, I mean, I think the skeleton arguments having been seen, the claimant now having seen the defendant's skeleton arguments, there's certainly a few points we would like to make, but more than happy to save them for closing rather than the opening.
Yes, as long as we observe that nobody is taken by surprise, and that is that nothing should be said in a closing submission that has not been identified in the opening, albeit, of course, the closing submission may be more fulsome and elaborate on the points, but providing that there are no new matters and different matters going to be raised in closing, then there's no need for an opening submission. Similarly, in broad terms, I would expect counsel to follow the traditional rules that if you are going to contradict a witness in closing submissions, then you will put the matter to the witness and give the witness an opportunity to deal with it in the course of examination. If we follow those usual rules, then I think we can skip the opening submissions and save some time that way to ensure that we get finished within the day.
Mm-hmm.
All right.
You're right. I do have one query actually.
Yeah.
Do you require the parties to agree a protocol in terms of the online hearing, in terms of witnesses having other people in the room when they're giving evidence? And
yes, I expect that when the witness gives evidence, there would not be anybody else in the room with them. I'm conscious sometimes there are logistical problems. Does that create a problem for you, Mr. Bull?
I don't believe so, but it's something I've done in other trials, and
Yeah.
we just filing skeleton arguments the business day before today's hearing. It's just not something that we had talked about, and
Right.
I'm not yet sure if the DAFC court has a standard form protocol yet or not. But previously they didn't.
I'm not aware of it. I have
Okay.
to tell you that. Mr. Lee, from your part, is it logistics, is it practical for Ms. Kakari to give her evidence from a room on her own?
Your Honour, yes. So we are intending to physically be in Dubai, and we're making arrangements with a local law firm for the provision of 2 rooms. So yes, when she's giving evidence, she'll be in her own room. Yes, and because she's our client, I mean, when she's not giving evidence, she will sit with us to give us instructions. Yes.
Yes, and if it's yes, that's sufficient.
Yes, Your Honour, thank you.
I don't,
yes,
Mr. Bull, I don't propose to make any more formal arrangements.
Yeah, no, I'm more than happy with that.
Everybody understands what the expectation is, and we'll go from there. All right. Anything else?
Not from the defendant.
All right. Well, thank you both. I thank the court officers, and we will now adjourn. That concludes today's hearing. Thank you.
Thank you, Your Honour.